Good morning, everyone present here. Hope you all are keeping well and safe. I, Ashwi Shah, welcome you all for a national online webinar series on mediation, hosted by Sayajirao Center for Alternate Dispute Resolution, conducted by Faculty of Law, the MAHARAJA Sayajirao University of Baroda, in collaboration with Mediators, India. Mediation is an age-old process of dispute resolution, practiced since the Vedic period. It is a low cost, keeping the matters, especially family matters, secret among the parties and the mediators. Moreover, the solution is also not imposed on any of the parties. It is a solution that both the parties agree to. It gives an effective solution in a peaceful manner. Thus, for aiding the participants in bringing awareness for social transformation, we are conducting this mediation webinar series. Today, we are having an inaugural session on the first webinar of our mediation series. For our inaugural session, we are obliged to have with us our distinguished speaker, Honorable Justice R.M. Chaya, a judge, High Court of Gujarat, and Ms. Pooja Anand, an advocate and mediator, to enlighten us with their knowledge and experiences. I welcome you, sir and madam, on behalf of Faculty of Law, the MAHARAJA Sayajirao University of Baroda. We also do have with us Ms. Kavita Balakrishna, Advocate, Mediator, Secretary, Mediators India. Welcome to you too, madam. Before starting with today's session, I would request all the participants to follow the webinar etiquettes for the smooth session. Please keep your mics muted and cameras off during the whole time. Do not use share screen option. In case of any questions related to the session, kindly mail us on scadr-law@mscbaroda.ac.in so that we can put up the same before our speakers during our question and answer session. Now, with that, I request Ms. Zankna ma'am to play the university song. I would request all the attendees to kindly please stand up for the university song.
Ssadr Thank you, Kavita ma'am. Now I request Dr. Kavita Goel ma'am, Assistant Professor, the Faculty of Law, the Maharaja Sayajirao University of Baroda, to introduce our Dean, OSD, Professor Dr. Uma Iyer ma'am. Over to you, Kavita ma'am.
Thank you, Ishwina. A very good morning to one and all present here. Respected Professor Uma Iyer, Webinar Series Director, distinguished speaker, Honorable Mr. Justice R.M. Chaya, Ms. Pooja Anand, Advocate and Mediator, Dr. Namrata Luhar, Webinar Convener, Ms. Kavita Bhatia, Webinar Coordinator, my dear colleagues at the faculty, members of Mediator India, and dear participants. I welcome you all on the first day of online webinar series on mediation. It is indeed a great privilege to introduce Professor Uma Iyer ma'am. Ma'am has added several ornaments to her academic and administrative position in her vast illustrious career. Madam presently is the officer on special duty on Faculty of Law and Director of MDC and former Dean of Faculty of Family and Community Sciences. She has also been the member of Senate and Syndicate of the Maharaja Sayajirao University of Baroda. Ma'am is the distinguished academician with the specialization in food and nutrition and having teaching experience of nearly 3 decades. Her area of research has been the dietary management of non-communicable diseases like diabetes, heart disease, etc., as well as the adolescent nutrition, especially with focus on midday meal scheme, where she has also been invited as a reviewer for midday meal scheme for different states of India by Ministry of MHRDC. She has also been on board of eminent bodies of different universities as well as the committees of the Government of India like FSSAI as well as the Government of Gujarat in relation to nutrition. Ma'am has a vast research experience which includes 2 books to her credit and nearly 100 research papers published in various national and international journals. Ma'am is also the recipient of many national and international awards from eminent institutions or organizations like Indian Dietetic Association and Sardar Patel University, Home Science Association of India, ISF THS at Jawaharlal Nehru University, AIIMS at New Delhi, Charotar University of Science and Technology, etc. Ma'am has also been the principal investigator of various minor and major projects funded by government, Britannia Industry Limited, NGOs, and industries like ICMR, JRF, UGC, Kellogg's India Limited, WHO, ICMR, Patronat LNG Limited, GACL, GIPCL, GSFC, Jivraj Mehta Smarak Health Foundation, Jivraj Mehta Hospital, Ahmedabad. MEM has also contributed in the development of e-content on various topics of e-Pathshala. Recently, Faculty of Law has been ranked first in the state of Gujarat and third in the top outstanding law schools of excellence by I wish under her dynamic leadership, Faculty of Law achieve new heights. Thank you, ma'am. Now I request our respected Professor Uma Iyer, madam, to deliver welcome address. Over to you, ma'am.
Thank you, Kavita, and good morning, everyone. Respected Honorable Vice Chancellor of the Maharaja Sayajirao University of Baroda, Professor Vijay Kumar Srivastava, our Chief Guest and Keynote Speaker, Honorable Mr. Justice R.M. Chaya, Advocate and Mediator, Ms. Pooja Anand, our webinar conveners, Dr. Namrata Solanki from the Maharaja Sayajirao University, and Ms. Kavita Balakrishnan from Mediators India, webinar coordinator, Ms. Kavita Bhatia, all the colleagues of the Faculty of Law, dear students and participants. It gives me great pleasure to welcome you all to today's National Webinar Series on Mediation, jointly organized by the Sayajirao Center for Alternate Dispute Resolution of the Faculty of Law of the Maharaja Sayajirao University and Mediators India. In all, 5 sessions with 10 experienced, dynamic, versatile speakers have been planned by the 2 collaborating partners to update and enrich the gathering on mediation. We all know that the Mediation Bill 2021 was introduced in the Rajya Sabha on December 20th December 2021. Mediation is a form of alternate dispute resolution where parties attempt to settle their dispute outside courts with the assistance of an independent third person, that is the mediator. The bill states that the mediation settlement agreement will have the status of a judgment or decree of a court, which will be binding. This will go a long way in ensuring that agreements arrived at through mediation are recognized and enforced by the law. In order to understand the various aspects related to mediation, several sessions have been planned, like importance of mediation in current age, fundamentals of mediation and understanding conflicts, civil and family mediation, implicit biases in mediation, commercial mediation, online mediation, courtroom observations on mediation, importance of UN Citrel and Singapore Convention, community mediation, and the role of youth in mediation movement. This wide range of topics would help to understand the various facets and dimensions that are related to mediation. I hope that this online mediation series will provide valuable inputs and skills towards the mediation process. Once again, I welcome you all to the interesting session on mediation. Thank you.
Thank you so much, Umayya ma'am. Now I request Ms. Kavita Bhatia, Assistant Professor, the Faculty of Law, to give introduction of SCADR.
Thank you, Namrata ma'am. A very good morning and very warm welcome to all. Respected Professor Umayya madam, esteemed speaker of the webinar, respected senior members of the faculty, dear colleagues and dear participants. It's my privilege to introduce SCADR. The Maharaja Sayajirao Gaikwad III was very visionary ruler. He has tried to bring reforms in education and all other fields, including judiciary. Maharaja Sayajirao Gaikwad III has established magnificent court buildings and appointed judges for speedy disposal of cases. Considering ADR as a significant mechanism to resolve disputes when courts are burdened with cases, the Sayajirao Center for Alternative Dispute Resolution, Faculty of Law, the Maharaja Sayajirao University of Baroda, was established in the year 2021 with a primary objective to enhance activities in the field of alternative dispute resolution. The other significant objective of the SCADR is to impart clinical education in the emerging field of ADR and to encourage law graduates to opt a career option as ADR counsels, ADR advisors, ADR consultants, and also as arbitrator, conciliator, mediators, and negotiators. The other objectives of the SCADR includes to enhance and support ADR activities, to develop effective conflict resolution skills among students and young lawyers who intend to practice and to become ADR practitioners, to facilitate and develop research and development in ADR, to organize national and international events and competitions on ADR, to offer certificate courses on ADR mechanism, to offer professional skills to the disputant parties for resolution of disputes, to offer consultancy to institutions, organizations, and corporates. This was all objectives of SCADR, which are planned ahead. Now, I request Dr. Namrata Luhar, Assistant Professor, Faculty of Law, to introduce the mediation series. Over to you, Namrata ma'am.
Thank you, Ms. Kavita Bhatia.
A very good morning to Professor V.K. Srivastava, patron of the National Webinar Series on Mediation and Honorable Vice Chancellor of the MAHARAJA Sayajirao University of Baroda, Professor Uma Iyer, OSD, Dean, Faculty of Law, and the Webinar Director, Ms. Kavita Balakrishnan, co-convener of the webinar, Ms. Kavita Bhatia, coordinator of the webinar, our distinguished speakers, Honorable Mr. Justice R.M. Chaya and Ms. Pooja Anand, participants, my colleagues from the Faculty of Law, attendees, and students. Since the establishment of Sayajirao Center for Alternate Dispute Resolution, we have been looking forward for holding activities in the field of alternate dispute resolution. As Ms. Kavita Bhatia has said, that the objective of the Sayajirao Center for Alternate Dispute Resolution is to boost ADR activities. We are fortunate enough to have with us collaborating Mediators India, who has collaborated with us, and that is the reason the National Webinar Series on Mediation is going to be organized in the month of February and March. The webinar series will be conducted on Saturdays starting from today, that is 12th of February 2022, and the last webinar will be held on 12th of March 2022. The series is been planned, has a very specific objective to discuss about the nuances of mediation, and for that we have planned different topics which will be deliberated and discussed, like civil and family mediation, importance of mediation, understanding conflicts, online mediation, community mediation, so on and so forth. We have with us on our board eminent judicial officers, former judges of the High Court of Gujarat, advocates, and eminent mediators of the country who will be sharing their experiences and wisdom with the participants. Each of the webinar will be having a question and answer session when the participants will be given an opportunity to interact with the speakers. I'm very sure that all these sessions to go from today will provide an overall and holistic view about mediation, the ins and outs of the mediation, and will definitely help all of us in understanding mediation, the legal aspects of mediation in a much better manner. As mediation is seen as a very good career option for the students, especially the law students, I'm very sure that the budding lawyers will be able to gain a lot of experience and will be able to understand mediation and the intricacies involved in mediation in much depth. This is just an overview of what we are going to do from today till 12th of March. I'm very sure the participants attending the series will be getting a lot of knowledge, as we are also going to get the knowledge. With these words, I would like to tell that today we are having Honorable Mr. Justice R.M. Chaya, Judge of the High Court of Gujarat, who will be talking about the importance of mediation. As we all know that mediation is very important, and at the same time, the courts have also took this concept further and is being seen as one of the best methods for resolving the conflicts. We are looking forward to listen to you, sir. We have with us Ms. Pooja Anand, who will be talking about understanding conflicts and the fundamentals of mediation. And we are looking forward to you as well, ma'am. Hope the session will be enriching and intellectually stimulating. I wish you all a very happy learning. Wish you all the best. And with this, we can take the program further. Thank you, everyone. And thank you, SCADR, for giving me this opportunity. Thank you. We may now request Ms. Kavita Balakrishnan, ma'am, to speak about Mediators India as to what the organization is. Over to you, ma'am. Thank you.
Thank you, Namrataji. It has been about 2 decades since the Mediation and Conciliation Project Committee of the Supreme Court took the decision to introduce court-annexed mediation in India. However, over the years, it was felt that there was a need for an establishment of a body that would not only be a forum of mediators fraternity in India, but also to understand, assimilate, collaborate, and share knowledge and good practice in the field of mediation, and also to create awareness about mediation at large. With this intent, the senior mediators across India set the foundation of Mediators India in the year 2017. Mediators India is a national association of Indian mediators. It is the largest growing network of association of mediators in India. It was started with the aim to create a network of mediators in India and to educate, promote, create awareness of mediation as an effective alternative to adversarial system. The association is proud to have the Honorable Supreme Court judges, High Court judges, ADR experts, and senior mediators in the country as its patron and members. To name a few stalwarts like late Mr. D.S. Parikh, Mr. Niranjan Bhatt, Mr. Sriram Panju, Mrs. Sheila Balsari, Mrs. Laila Olapalli, Mrs. Uma Ramanathan, Mr. Anil Xavier, Mr. A.J. Jawad belongs to Mediators India. That is not all. The members of Mediators include not just senior mediators, but also young professionals who are exploring the field of mediation. The organization provides a platform where the mediators engage with each other, both formally and informally, irrespective of their age or seniority, to explore about mediation. To quote an event, when the government asked the senior members for their inputs on the proposed Mediation Bill 2021, our young members had not only an opportunity to express their views, but also to debate with the senior mediators. Believe me, it was a very enriching experience. We at Mediators India have, over the past 4-5 years of our existence, have undertaken several programs, including in collaboration with universities and other organizations. Mediators India is determined to take mediations to younger people. The future of dispute resolution lies in the hands of the future generation, and it is a moment of pride for us to collaborate with the ADR faculty of this esteemed university. Further, we have several new programs and initiatives lined up. So keep a lookout for the announcement. The details will be available on our Facebook and LinkedIn pages. If you want to know more about us, please feel free to contact us. And I would like to conclude with the words of the great Greek philosopher Epictetus. If at some point of time in your life, if you should find anything better than justice, honesty, self-control, and courage, embrace it without reservation. It must be an extraordinary thing indeed, and it perfectly defines mediation. Now it is time to embrace mediation. Thank you. And now over to Namrata. Thank you, Namrata ji.
Thank you, Ms. Kavita Balakrishnan ma'am, for introducing Mediators India. Let us now move ahead with the webinar. And for this, I request Dr. Archana Gadekar, Associate Professor, Faculty of Law, to introduce our distinguished speaker of the day and the chief guest of the National Webinar Series on Mediation, Honorable Mr. Justice R.M. Chaya, Judge, High Court of Gujarat. Over to you, ma'am.
Respected Honorable Mr. Justice R.M. Chaya, Judge, High Court of Gujarat, and the keynote speaker for today, Ms. Pooja Anand, mediator, and our eminent speaker for the day, Professor Uma Iyer, OSD Faculty of Law and Webinar Series Director, Ms. Kavita Balakrishnan and Dr. Namrata Luhar, the webinar conveners, Ms. Kavita Bhatia, webinar coordinator, my colleagues at the Faculty of Law, and dear participants who have joined us virtually. A very good morning to you all. It is a matter of great privilege to introduce Honorable Mr. Justice R.M. Chaya to this August virtual gathering. At the outset, I am happy to share with you all that His Lordship is an alumnus of the MAHARAJA Sayajirao University of Baroda. His Lordship, after completing his graduation in Commerce from the Faculty of Commerce, the MAHARAJA Sayajirao University of Baroda, went on to pursue law from the Gujarat University. His Lordship
Before adjourning the bench, I had a more than 2.5 decades long illustrious career as a lawyer. After beginning his career with the famous Y.J. Trivedi and Sons and Company, his lordship was empaneled as advocate for various municipal corporations in Gujarat. During his stint as a lawyer, his lordship has represented the state and union government in various capacities as assistant government pleader, additional public prosecutor, additional counsel for income tax, central government standing counsel, and senior standing counsel for the Union of India. Also, before being elevated to the bench, his lordship was on the panel of mediators of the High Court. His lordship was elevated as Judge High Court of Gujarat in 2011 and confirmed as permanent judge in January 2013. Recently, his lordship was acting Chief Justice of Gujarat High Court for some period. Presently, his lordship is the executive chairman of the Gujarat Legal Service Authority and member Mediation Monitoring Committee of High Court of Gujarat. It is a matter of honor for us that Honorable Mr. Justice R.M. Chaya has kindly consented and accepted our invitation and has agreed to deliver the keynote address in this national webinar series on mediation, which is spread over 5 weeks, organized by the Sayajirao Center for Alternate Dispute Resolution. I invite your lordship to deliver the keynote address. Over to you, sir.
Sections of the society, which subsequently received statutory recognition by enactment of the Legal Service Authorities Act 1987. This noble initiative was implemented to secure the faith of rural masses in social justice and promote the ideas of equality before law and equal protection before law as embedded in our Constitution. In such village-level people's court, trained mediators presided over the dispute resolution process and ensured the participation of village men in arriving at a mutually agreeable decisions, since litigation cost and delay. The statutory foundation provided by the Act awarded legal recognition to the decisions made by the Lok Adalats and conspicuously helped to uphold the cause of quick and inexpensive justice to the poor and needy. Introduction of Section 89 and Order 10 Rule 1A and 1B and 1C by way of 1999 amendment in the Code of Civil Procedure 1908 is a radical advancement made by the Indian legislature in embracing the system of court-referred ADR. Section 89 of the Code confers on the court the authority to refer certain disputes for resolution if there exists an element of settlement which may be acceptable to the parties. The law codified in Section 89 of the Code recognizes 4 different types of methods under ADR stated as under. Arbitration. Arbitration involves procedurally simplified and expedited fact-finding and decision by a neutral third party, which decision is only binding on the parties in the instant case and carries no precedential effect. Conciliation involves direct discussion and bargaining between disputing parties to arrive at a mutually acceptable resolution of disputed issues. Part Roman 3 of the Act, comprising sections 61 to 81, deal with the procedure for conciliation. Mediation is a voluntary and consensual process wherein the disputing parties are assisted in reaching a mutually agreeable settlement by a neutral third party, whose role is to facilitate communications and discussions, but who has no decision-making power. Judicial settlement, including settlement through Lok Adalat, as I have elaborated above. From the above referred discussion, it can be easily said that there are 2 types of dispute resolutions. One is adjudication, binding form of dispute resolution with the help of third party, and second is negotiation, that is non-binding form of dispute resolution and the same can be summarized into two main divisions: adjudication and non-adjudication, and ultimately mediation is part of the non-adjudication process. Section 89 is generally understood as the only provision in the code which provides for out-of-court settlement. But there are many other provisions under the code which support and promote settlement. Such provisions are present in form of Section 80, Section 107, Subsection 2, Section 147, Rule 3 of Order 23, Rule 5B of Order 27, Order 32A, Rule 1A, Order 36 of CPC. Such provisions are also present in Industrial Dispute Act, Hindu Marriage Act, Family Court Act, etc. Regarding the dispute resolution function of private law, there are varieties of functional equivalents to litigation available, which are collectively referred to as alternative dispute resolution. On the one hand, online dispute resolution relates to the resolution of disputes that result from online conduct, that is, from communications and transactions which come through the use of internet. Domain name disputes are a prominent example, as are disputes related to e-commerce. On the other hand, ODR relates to the use of online communication technology in resolution process, even if the dispute itself has an offline origin. The provision of alternative dispute resolution services on the internet has become quite popular. Online dispute resolution in India is in its infancy stage, but is gaining prominence day by day. With the enactment of Information Technology Act 2000, e-commerce and e-governance has been given a formal and legal recognition. Dispute resolution techniques range from methods where parties have full control of the procedure to methods where a third party is in control of both the process and the outcome. These primary methods of resolving disputes may be complicated with information and communication technology. When the process is conducted mainly online, it is referred to as ODR, that is to carry out most of the dispute resolution procedure online, including the initial filing, the neutral appointment, evidential processes, oral hearing, if needed, online discussions, and even the rendering of binding settlements. Thus, ODR is a different medium to resolve disputes from beginning to end, respecting due process principles. ODR was born from synergy between ADR and ICT as a method of resolving disputes that were arising online and for which traditional means of dispute resolution were inefficient or unavailable. An example of multi-step ADR, parties agree to mediate their disputes with the understanding that any issue not settled by mediation will be resolved by arbitration, using the same individual to act as both mediator and arbitrator. Having the same individual acting in both the roles, however, may have a chilling effect on the parties participating fully in mediation. In co-mediation arbitration, different individuals serve as neutrals in the arbitration and mediation sessions, although they may both participate in the parties' initial exchange of information. In arbitration mediation, the neutral first act as arbitrator, writing up an award and placing it in a sealed envelope. The neutral then proceeds to mediation stage, and if the case is settled in mediation, the envelope is never opened. It is worthy to note that mediator can work as arbitrator and vice versa, but conciliator cannot work as arbitrator unless otherwise agreed by the parties. Section 80 of Arbitration and Conciliation Act 1996 provides that the conciliator cannot act as an arbitrator, representative or counsel in any arbitral or judicial proceedings in respect of consolidated dispute, nor can he be presented by any party as witness in such proceedings. In divesting system of alternative dispute resolution, two principles must be adhered to. Firstly, such a system must remedy the self-reinforcing problems which beset the traditional litigative system. However, it is of importance that at the same time the peremptory norms of law, such as those of judicial accountability and integrity, are not lost in our impatient search for an alternative. Therefore, it is imperative that the system of ADR overcomes the litigative impediments through the permissible means, ensuring that the pillars of justice do not crumble in the name of an efficient alternative system. The need for public adjudication and normative judicial pronouncements on momentous issues of the day is fundamental to the evolution of law of land. ADR is necessary to complement and preserve this function of the courts. The objective of ADR is the provision of an outlet where petty and non-contentious disputes can be disposed of in a simple and speedy manner. Thus, a system of ADR has certain instrumental and functions, and this instrumental, insofar as it enables the amicable settlement of disputes through means which are not available to court. It is instinct because it enables the parties themselves to settle their disputes. Now I will discuss on the benefits of mediation. First benefit is being heard personally. In hearing and being heard in mediation forum, parties gain the understanding of the other party's point of view and enhance opportunity to be heard and understood themselves. Party-centric. Parties are empowered to decide for themselves whether and how they would like to resolve a situation. This self-determination aspect of mediation often corresponds to the higher aspirations of how individuals and businesses want to conduct their lives and do business generally. Third benefit is speedy disposal for once in for all. In resolving or narrowing disputes through mediation, parties avoid the delay of a third party or judicially decided outcome. Fourth benefit is economical. In resolving or narrowing areas of dispute through mediation, the parties save an enormous amount of time, energy, and expense associated with conflict and litigation. What transpires at a mediation can be kept confidential by agreement. Whether a mediation occurs before or after filing of a lawsuit, any form of communication generated at a mediation is normally inadmissible evidence. Other benefit is reality check opportunity. In private caucus, mediation can afford the opportunity to communicate important reality check information that may be easier for a client to accept. Win-win for both the parties. Through mediation, parties avoid the win-lose and lose-lose outcomes associated with litigation. Many parties who win in protected litigation often find the overall time, energy, and monetary commitment associated with litigation comes at an enormous cost and loss. Those who lose in litigation surely feel even worse about such an outcome. Mediation can spare parties from all this and enable them to move forward from disputes efficiently and effectively. I may also refer to the landmark judgments of the Honorable the Apex Court on the point of mediation, which many of you must be knowing. The Honorable Apex Court in the case of Efcons Infrastructure Limited versus Cherian Worke Construction Company Private Limited, reported in AIR 2010 Supreme Court Weekly 4983, as observed in paras 8 to 16, that as ADR processes were not being resorted to with the desired frequency, Parliament thought it fit to introduce Section 89 and Rules 1A to 1C in Order 10 of CPC to ensure that ADR process was resorted to before the commencement of trial in suits. Section 89 as worded, however, suffers from clerical or typographical defects. If Section 89 is read and required to be implemented in its literal sense, it will be a trial judge's nightmare. It puts the cart before the horse and lays down an impracticable, if not impossible procedure. The first anomaly is the mixing up of the definitions of mediation and judicial settlement under clauses C and D of subsection 2 of Section 89. When words are universally understood in particular sense and assigned a particular meaning in common parlance, the definitions of those words in Section 89 with interchange meanings has led to confusion, complications, and difficulties in implementation. The second anomaly is that subsection 1 of Section 89 imports the final stage of conciliation referred to in Section 73(1) of the Arbitration Act into the pre-ADR reference stage under Section 89 of CPC. Subsection 1 of Section 89 required the court to formulate the terms of settlement and give them to the parties for their observation, and then reformulate the terms of a possible settlement, and then refer the same for any one of the ADR processes. It will not be possible for a court to formulate the terms of settlement unless the judge discusses the matter in detail with both parties. The court formulating the terms of settlement merely on basis of pleadings is neither feasible nor possible. The requirement that the court should formulate the terms of settlement is therefore a great hindrance to courts in implementing Section 89. Therefore, proper interpretation of Section 89 requires two changes from a plain and literal reading of section. Firstly, it is not necessary for the court, before referring the parties to an ADR process, to formulate or reformulate the terms of possible settlement. It is sufficient if the court merely describes the nature of dispute in a sentence or two and makes the reference. Secondly, the definition of judicial settlement and mediation in clauses C and D of Section 89, subsection 2, shall have to be interchanged to correct the draftsman's error. The Honorable Apex Court has prescribed the procedure to be adopted by a court under Section 89 of the Code. The procedure to be adopted by the court under Section 89 of the Code is as under. When the pleadings are complete, before framing issues, the court can fix a preliminary hearing for appearance of parties. The court should acquaint itself with the facts of the case and the nature of dispute between the parties. The court should first consider whether the case falls under any of the categories of the cases which are required to be tried by the court and not fit to be referred to any ADR processes. If it finds that the case falls under any excluded category, it should record a brief order referring to the nature of the case and why it is not fit for reference to ADR processes. It will then proceed with the framing of issues and trial. In other cases, that is, the cases which can be referred to ADR processes, the court should explain the choice of 5 ADR processes to the parties to enable them to exercise their option. The court should first ascertain whether the parties are willing for arbitration. The court should inform the parties that the arbitration is an adjudicatory process by a chosen private forum, and reference to an arbitration will permanently take the suit outside the ambit of the court. The parties should also be informed that the cost of arbitration will have to be borne by them. only if both parties agree for arbitration and also agree upon the arbitrator, the matter should be referred to the arbitration. If the parties are not agreeable for arbitration, the court should ascertain whether the parties are agreeable for reference to conciliation, which will be governed by the provisions of the Act. If all the parties agree for reference to conciliation and agree for conciliator or conciliators, the court can refer the matter to conciliation in accordance with Section 64 of the Arbitration Act. If parties are not agreeable for arbitration and conciliation, which is likely to happen in most of the cases for want of consensus, the court should, keeping in view the preferences, options of the parties, refer the matter to any of the other three ADR processes, namely Lok Adalat, mediation by a neutral third-party mediator, a judicial settlement where a judge assists the parties to arrive at a settlement. If the case is simple, which can be completed in a single sitting, or cases relating to a matter where the legal principles are clearly settled and there is no personal animosity between the parties, as the case of motor accident claims, the court may refer the matter to Lok Adalat. In cases where the questions are complicated or cases which may require several rounds of negotiations, the court may refer the matter to mediation. Where the facility of mediation is not available, or where the parties opt for guidance of a judge to arrive at a settlement, the court may refer the matter to another judge for attempting settlement. If the reference to ADR process fails, on receipt of the report of ADR forum, the court shall proceed with the hearing of the suit. If there is settlement, the court shall examine the settlement and make a decree in terms of it, keeping the principles of Order 23, Rule 3 of the Code in mind. If the settlement includes disputes which are not the subject matter of the suit, the court may direct that the same will be governed by Section 74 of the Arbitration Act if it is a conciliation settlement, or Section 21 of the Legal Services Authorities Act 1987 if the settlement by Lok Adalat or by mediation, which is a deemed Lok Adalat. This will be necessary as many settlement agreements deal with not only the disputes which are the subject matter of the suit or proceeding in which the reference is made, but also other disputes which are not the subject matter of the suit. If any term of settlement is ex facie illegal or unenforceable, the court should draw the attention of the parties that to avoid further litigations and disputes about executability. It is also observed by Honorable Apex Court in Para 32 that the court should also bear in mind the following aspects which, while giving effect to Section 89 of the Code. If the reference is to arbitration or conciliation, the court has to record that the reference is by mutual consent. Nothing further need be stated in the order sheet. If the reference is to any other ADR process, the court should briefly record that having regard to the nature of dispute, the case deserves to be referred to Lok Adalat or mediation or judicial settlement, as the case may be. There is no need for an elaborate order for making the reference. The requirement in Section 89(1) of the 89(1) that the court should formulate or reformulate the terms of settlement would only mean that the court has to briefly refer to the nature of dispute and decide upon the appropriate ADR process. If the judge in charge of case assists the parties and if the settlement negotiations fail, he should not deal with the adjudication of the matter to avoid apprehensions of bias and prejudice. It is therefore advisable to refer cases proposed for judicial settlement to another judge. If the court refers the matter to an ADR process other than arbitration, it should keep track of matter by fixing a hearing date for ADR report. The period allotted for ADR process can normally vary from a week to 2 months, which may be extended in exceptional cases, depending upon the availability of the alternative forum, the nature of case, etc. Under no circumstances, the court should allow the ADR process to become a tool in the hands of litigant intent upon dragging of the proceedings. Normally, the court should not send the original record of the case when referring the matter to an ADR forum. It should make available only copies of relevant papers to the ADR forum. For this purpose, when pleadings are filed, the court may insist upon filing an extra copy. However, if the case is referred to a court-annexed mediation center, which is under the exclusive control and supervision of a judicial officer, the original file may be made available whenever necessary. It is observed in para 33 that the procedure and consequential aspects referred to in the earlier two paragraphs are intended to be general guidelines subject to changes as the concerned court may deem fit with reference to the special circumstances of a case. We have referred to the procedure and process rather elaborately, as we find that section 89 has been a non-starter with many courts. Though the process under section 89 appears to be lengthy and complicated, in practice, the process is simple. Know the dispute, exclude unfit cases, ascertain consent for arbitration or conciliation. If there is no consent, select Lok Adalat for simple cases, mediation for other cases, reserving reference to a judge-assisted settlement only in exceptional or special cases. In case of case Srinivas Rao versus D.A. Deepa reported in AIR 2013 Supreme Court 2176, the Honorable Apex Court has issued the following directions. A. In terms of Section 9 of the Family Court Act, the Family Court shall make all efforts to settle the matrimonial disputes through mediation. Even if the counselors submit a failure report, the Family Court shall, with consent of the parties, refer the matter to the mediation center. In such a case, however, the Family Court shall set a reasonable time limit for mediation centers to complete the process of mediation, because otherwise the resolution of disputes by the Family Court may get delayed. In a given case, if there is a good chance of settlement, the Family Court in its discretion can always extend the time limit. The criminal courts dealing with complaints under section 498A of IPC should at any stage, and particularly before they take up the complaint for hearing, refer the parties to mediation center if they feel that there exist elements of settlement and both the parties are willing. However, they should take care to see that in this exercise, rigor, purport, and the efficacy of section 498A of the IPC is not diluted. Needless to say that the discretion to grant or not to grant bail is not in any way curtailed by this direction. It will be for the concerned court to work out the modalities, taking into consideration the facts of each case. All mediation centers shall set up pre-litigation desk clinics, give them wide publicity, and make efforts to settle matrimonial disputes at pre-litigation stage. Similarly, in the case of Motiram versus Ashok Kumar reported in AIR 2011 Supreme Court Weekly 2078, the Honorable Supreme Court has observed that if the mediation succeeds by both the parties to the court without mentioning what transpired during the mediation proceedings, if the mediation is unsuccessful, then the mediator should write only one sentence in his report and send it to the court saying that the mediation has been unsuccessful. Beyond that, the mediator should not write anything which was discussed, proposed, or done during the mediation proceedings. This is because in mediation very often offers, counter offers, and proposals are made by the parties, but until and unless the parties reach an agreement signed by them, it will not amount to any concluded contract. If the happenings in the mediation proceedings are disclosed, it will destroy the confidentiality of the mediation process. In Suresh Narayan Kadam versus Central Bank of India, reported in 2016 Supreme Court 714, the Honorable Apex Court has observed in his forward written on 12th April 2011 to the first edition of Mediation, Practice and Law, the Path to Success Dispute Resolution, written by Mr. Sriram Panchu, Senior Advocate and Mediator, Mr. Fali Nariman, a Senior Advocate of this court and respected jurist, writes, the same, I quote, the same subject matter of disputation between two parties can be dealt in two different ways, not necessarily exclusive. First, by attempting to resolve the dispute in such a way that the parties involved win as much as possible, and lose as little as possible through the intervention of a third party stepped in the tactics of mediation. And second, failing this, the dispute would be left to be resolved by each party presenting its case before a disinterested third party, with an exception of a binding decision on merits of the case, a win all, lose all final determination. It is true that all matters cannot be mediated, but the matters which can be mediated comprise of, but not limited to, the commercial contractual disputes, consumer matters, and those involving tortious liability. Having said that, now I shall discuss on the fit and unfit cases. According to me, following are the cases which normally considered to be not suitable or considered unfit for ADR process, having regard to their nature. 1. Representative suits under Order 1, Rule 8 CPC, which involves public interest or interest of numerous persons who are not parties before the court. In fact, even a compromise in such a suit is a difficult process, requiring notice to persons interested in the suit before its acceptance. Second, disputes relating to election to public offices. Third, cases involving grant of authority by the court after inquiry, as for example, suits for grant of probate or letters of administration. Next, cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, etc. Cases requiring protection of courts, as for example, claims against minor, deities, mentally challenged, and suits for declaration of title against the government. Cases involving prosecution for criminal offenses. All other suits and cases of civil nature, in particular, the following categories of cases where pending in civil courts or other special tribunal forum are normally suitable for ADI process. To list few of them, all cases relating to trade, commerce, and contracts, including disputes arising out of contracts, including all money claims, disputes relating to specific performance, disputes between supplier and consumer, disputes between banker and consumers or customers, disputes between developers, builders, and customers, disputes between landlords and tenants, licensor and licensees, disputes between insurer and insured, all cases arising from sourced relationships, including disputes relating to matrimonial causes, maintenance, custody of children, disputes relating to partition, division among family members, co-partners or co-owners, and disputes relating to partnership among partners. All cases where there is a need of continuation of pre-existing relationship in spite of disputes, including disputes between neighbors relating to easementary rights, encroachment, nuisance, etc., disputes between employers and employee, disputes among members of the society, association, apartment and owners association, all cases relating to tortious liability, including claims for compensation in motor accident claims, all consumer disputes, including disputes where a trader, supplier, manufacturer, service provider is keen to maintain his business, professional reputation, and credibility or product popularity. The above narration of suitable and unsuitable categorization of cases is not intended to be exhaustive or rigid. They are illustrative in nature, which can be subjected to just exceptions or additions by the court, tribunal, exercising its jurisdiction and or discretion in referring a dispute to an ADR process. The Gujarat Legal Services Authority and the Mediation Monitoring Committee of the High Court has taken some steps for the upliftment of mediation movement. Along with the notices to be issued to known applicants, short details of availability of mediation facilities and how it can be availed is provided. This practice is followed not only by the High Court, but all trial courts. Continuous awareness programs of judicial officers and other stakeholders and regular training and capsule courses, refresher trainings, for the master trainers are conducted. Even during the difficult times of pandemic, the Mediation Monitoring Committee of the High Court conducted 2 days exhaustive program for judicial officers and other stakeholders. The Mediation Monitoring Committee of the High Court had introduced the scheme for identification of cases for mediation, reference as a measure to improve mediation activities in the state of Gujarat. The Gujarat State Legal Services Authority has also introduced the standard operating procedure for pre-institution mediation under the Commercial Court Act through online mode. Since all taluka courts do not have the facility of mediation center and services of NCPC trained mediators, some district courts have introduced SOP for online mediation. Before concluding, I may quote the well-known words of Mahatma Gandhi. I quote, "My joy was boundless. I had learned the true practice of law. I had learned to find out the better side of human nature and enter man's heart. I realized that the true function of a lawyer was to unite parties, even asunder. A large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases." I unquote. Thank you very much.
Valuable inputs and the wonderful insight. Thank you so much.